So in this section, we're just going to discuss the differences between complete and incomplete defenses, and then we're going to be looking at insanity, right? Intoxication and Doli Incapax, right? The other defenses we did already, all right? So complete defenses now. We know that complete defenses are also known as full defenses, right? And these result in the defendant being acquitted, right? Absolved of criminal liability, right? If successfully raised and proven, complete defenses excuse the defendant's conduct entirely, meaning that they are not found guilty of the offense. All right? Complete defenses include self-defense, defense of others, defense of property, consent, insanity, non-insane automatism, duress, mistake of fact, and necessity. What are the ones that we look at in Law Unit 1? Anyone? Or the ones that we look at in Law Unit 1? Duffy? We look at insanity, right? We look at insanity, we look at self-defense, and we look at the non-insane automatism, right? Self-defense can entail defense of others and defense of property, technically, right? And I did speak about necessity, even though it's technically not in the syllabus. But I think necessity just makes sense. It's one of the easiest ones, so why not understand that as well? It's even in the name, all right? Consent is technically a defense to battery. Technically we talk about it, but it's not a full defense though, right? So we have to talk about that. So self-defense now. Self-defense occurs when an individual uses reasonable force, right? It must be reasonable force. So somebody can't go and slap you on your hand and you shoot them in the face. That is not reasonable force, right? To protect themselves or others from imminent harm or danger. If the defendant reasonably believed that their actions were necessary to defend against an imminent threat or harm and use no more force than was reasonably necessary, right? They may be acquitted based on self-defense. All right, look at that, and it must be reasonable. So if you mad out, if you sick out, right, and you decide, say, if somebody touch your pencil, you're gonna shoot them, right? That is not self-defense. You cannot believe from now until thine kingdom comes as self-defense. No, it must be of a reasonable man, right? A reasonable man or a reasonable person must decide that that would have been a reasonable action to take, right? If not, self-defense shouldn't have been your defense. It should have been insanity. We'll discuss those things, right? So looking at there now, essentially, right, it's in defense of oneself, one's family, or defense of one's property. All of those type of things would be a part of the defense, right? So of RV, all we know, right? RV, Clegg, Palmer v. R, Shaw v. R, Beckford v. Regina. Look at all the cases for self-defense, right? So speak about those cases. So I'll discuss RV Owino, right? Should I want to? Okay, RV Owino is like a locus classicus, right, for self-defense, right? So basically, O was convicted of assaulting his wife, occasioning actual bodily harm. In his defense, O advanced that he used reasonable force to prevent her from assaulting him. So in that case, it looked at that, right? So O, look at that. He was convicted, and an appeal on the ground that the judge failed to direct the jury. The test was a reasonable force or subjective. Alright, lovely. So we could look at that. It was a failure of direction. So per incuriam, and it was sent out, right? Locus classicus generally speaks to the leading case, right? It speaks to a location, right, of a specific rule per se. Right, so where rules are found, we generally call them locus classicus, or the major case in which all precedent really stems from, we generally call them the locus classicus, right? So we have that there, right? So there are many things, even Palmer v. R, which is a Jamaican case, right? There are many parts of the self-defense. So in Palmer v. R, right, this was an appeal from Jamaica to the Privy Council based on the shooting to death of a man, right, by Palmer, right? Palmer and a group of men went to buy marijuana. A dispute arose rather, and Palmer and the others took the marijuana and left without paying for it. They were chased, and Palmer used a gun, right? He had on with him to shoot the deceased, right? So looking at that, he appealed against conviction on the ground of self-defense, and his appeal was dismissed. He was being chased, and he used a gun to kill the deceased. So there was not actual reasonable force. So all of these different things must be taken into consideration. These are your cases. Incomplete defense now. Well, I mean, I should have spoke about insanity because insanity is a complete defense. But incomplete defenses now, right, are known as partial defenses, mitigating factors, right, and do not result in complete acquittal, right? They might lessen the charge or actually lead to more leniency, right, by the courts. So provocation, diminished responsibility, intoxicity, and infancy, right? So insanity is actually a complete defense, so don't mind that, right? But infancy is a part of it. But let's look at this. For insanity being a complete defense, now we know insanity is a legal defense, right? Involving the claim that the defendant was suffering from severe mental illness or defect of at the time, right, of the crime, while impaired their ability to understand the nature of their actions or distinguish right from wrong. So the Benarton rules, right? Presumption of sanity must be made. So every individual is presumed to be sane and responsible for their actions unless proved otherwise. Defect of reason, there must be a defect of reason due to a disease of the mind, right? This means that the defendant's cognitive faculties were impaired to the extent that they could not think rationally or understand their actions, right? Inability to understand the nature of the and quantity of the act, right? Quality of the act, rather, right? The defendant must be unable to understand the nature or quality of the act, right? So notice, Bratty versus the Attorney General of Northern Ireland, these are the things that they brought out in that case. Inability to know right from wrong. Alternatively, the defendant must have been unable to distinguish between right and wrong concerning their act. This means that even if the defendant understood what they were doing, they did not realize that the actions were legally or morally wrong. So look at those for the Pentateuch rules. And following those of the disease of mind by R.V. Kempt and R.V. Sullivan, defect of reason is covered in R.V. Clark and R.V. Windle, right? And uncontrollable impulse is controlled in R.V. Sodom and VR, right? So those are the cases that we use for insanity. All right. So if I look at those cases, you can note them down. Give me a moment, I'll return. Alright. I'm constantly checking chat to make sure there if there are any questions they are answered. For intoxication now, we spoke about voluntary and involuntary we talk about voluntary actually. Alright, so voluntary intoxication occurs when somebody willingly consumes intoxicating substances, so alcohol or drugs, knowing their potential effects. Right? So these lead to crimes of specific intents like murder, theft, and those type of things, right? So basic intent crimes now, right, speak to things like okay, these rule out crimes of specific intent, I believe, right? So it can be shown that the defendant was in this case, right, voluntary intoxication may be a defense if it is shown that the defendant was so intoxicated that they could not reach the requisite forms of intent, right? So that's a burden of proof for specific intent crimes actually, right? So you need to be able to show that you're so intoxicated that you could not actually have intended, right, to commit the crime. For basic intent crimes now, voluntary intoxication is generally not a defense here. This is because the act of getting intoxicated is seen as reckless behavior, and recklessness suffices to establish the mens rea of basic intent crimes. Here we bring ourselves back to DPP v. Majewski and DPP v. Morgan. Right? These two cases are important here. Okay? For involuntary intoxication now, we're talking about the how someone gets intoxicated without their knowledge or against their will. We'll look at those type of things now. How do we apply these things now, right? So involuntary intoxication can be a defense for both specific and basic intent crimes now, right? So since you didn't do it by yourself, it's actually a defense for basic intent crimes now, right? So if the person unknowingly was drugged and commits a crime, they may argue that they lack the necessary intent or awareness due to the involuntary intoxication, right? And we also have a bit of automatism under this, and we can look at that as it relates to RV Kingston. What happened in RV Kingston? Anybody? Police officer? Question mark. Alright. RV Kingston? Alright, so looking at that. So K, a pedophilic homosexual, was convicted of indecent assault of a 15-year-old boy. He had been drugged, right, by one, right, person, right, who was seeking to blackmail K, right? P who was seeking to blackmail K Kingston, right? So looking at that, right? So the person who was seeking to blackmail K had procured the boy who was also drugged. P then induced K to assault the boy. In his defense, K argued that the drink had been laced, right? And that he had remembered seeing the boy on the bed, but remembered nothing afterwards. So in here now we have involuntary intoxication, right? But one important voluntary intoxication case would have been like RV Tandy. So I wanted to mention that as well, because RV Tandy would have been implemental here as well, right? But we know that the person actually was an alcoholic and she drank vodka, right, and strangled the young girl, right? And pleaded diminished responsibility, but insanity was actually a better case there, right? As an alcoholic. So let's look at this here now. The defense of infancy now. Infancy, right? Not infancy, but infancy, right? The defense of Doli Incapax, right, is here. Doli Incapax is a legal doctrine that presumes a child is incapable of forming the intent to commit a crime. The defense is typically applied to young children under a certain age, right? So it depends on which age Doli Incapax is afforded, right, to in your specific constitutions or your specific legislations, right? Age of presumption. Children below the age of around, usually often 10, I think in Jamaica it's around 12 or 14, right, are presumed to be incapable of committing a crime, right, or committing criminal intent. So they can commit the actus reus, but they have no intent at all, no mens rea at all. Therefore, what we talk about, there's no coincidence of the actus reus and the mens rea. Actus non facit nisi mensit rea. Okay. And you also have rebuttable presumption. For children of a specific age range, the prosecution must provide evidence to prove that the child knew their actions. So there's a high burden of proof here, right? So what happened here? Which case could we use here? Fadali Incapax. We could use Bird, right? RV Bird, meaning like actually BIRD, Bird. Don't we have a case like that? Not sure. You have RV Bird, man. You know have RV Bird? I think it's RV Bird. Is it RV Bird? Let me check something. Let me make sure that it's RV Bird in this little book here. RV Bird. RV Bird, lovely. Alright. RV Bird 1992. A young defendant took a vehicle without the consent of the owner and committed several driving offenses. The English Court of Appeal weighed the fact that the defendant had accelerated towards the police cars and collided into two of them against the fact that he was a young man of only 17 who had pleaded guilty. On appeal, his custodial sentence of 15 months was reduced to 12 months. Since the mitigating factors were not overwhelming, the Court of Appeal did not significantly reduce the sentence, right? So this can be an incomplete defense, so they reduce his defense because of his age. Doli Incapax is there. But Doli Incapax usually works for persons that are way below that age. Right? Tends to be way below that age. I know that Edwin Farfan v. the State cannot work there though. That would be different. That would be like insanity. But there are other. Let's say that someone, right? Let's say that. Okay, so Doli Incapax protect even the smaller children. Like let's say that a 9-year-old, right? I think there was a case. I don't remember the name of the case, right? I think it was a 9-year-old or a 12-year-old, right? Was playing with a toy, and the father took away the toy from the young child, right? And the child got in a fit of rage, right? You know, children have fits of rage, right? And then actually took up a knife and actually stabbed the father to death. And the child was under the defense of Doli Incapax, because they were saying that the child had no idea what it was doing. But I believe that if a child, right, is of that age, they do have some amount of knowledge that a knife going in and out of their parents could necessarily kill them. But they're saying that the child did not have any ability to presume or to form criminal intent. So anybody below statutory age, right, can be used, right? So that can work for that defense, yes. Anybody below statutory age, alright? So I spoke about all of these things. That should be lovely. And that is where we end.